Thank you very much for joining today's webinar, which is all about wills, wealth, and what's ifs. My name is Nick Charalambous, and I'm the Managing Director of Alpha Wealth, and I'm delighted to be joined by Carrie McDermott, who's Principal of MDM Solicitors, and also a colleague of mine, Cleona O'Donoghue, who's our Director of Business Development. The webinar has been recorded on the 9th of October at 1 p.m. Also, I'm conscious that some of you may be listening to this recorded. We really want to just try and give, I suppose, a little bit of value add in relation to the whole aspect of, I suppose, legal affairs that we deal with in our daily lives. And many of us maybe not really kind of conscious of the things that we should probably be doing from a planning point of view. And as I said, I'm delighted to have Carrie with us. Just very briefly as an introduction, my colleague's going to pop up a poll, just trying to get some engagement, obviously, while numbers are settling. But for those of you that are not familiar with Alpha Wealth, just myself, I'm managing director. I set up Alpha Wealth 14 years ago. We have 14 staff based, primarily core, small presence in Dublin. Carrie McDermott herself, and I'm sure she introduced herself, has 2 offices in Cork and Dublin, and she runs her own very successful legal practice. Just with regards to the agenda, we're going to cover off some very important, I suppose, legal aspects of things like wills, particularly enduring power of attorney, which is something that I come across quite regularly as a financial planner. We are going to touch on the area of gift and inheritance tax planning, and we really want to make this session as interactive as possible. So we would encourage any questions. If you could put them into the chat, colleague Cleaner is going to be kind of looking after that session. Carrie will try to address as many questions as possible, and if not during the session, we will certainly endeavour to do those afterwards. And Carrie is kindly provided, I suppose, her legal expertise, and also obviously in relation to covering any aspects that is being covered off today, and obviously Alpha Wealth from a financial perspective. So without further ado, as I said, I'm going to try and keep this session short and snappy. Please do ask questions through the chat. And I'm just going to start with the area of wills. And I'd like to bring Carrie in just in relation to this particular area.
Thank you, Nick. Thank you, Cleona. Nice to meet you all, and looking forward to an interesting session. Lots of sort of general information on things that people generally just don't think about in daily life, but that nevertheless are probably up there with lists of priorities that should be given contemplation and consideration. For me, I suppose, as a solicitor, I see people coming dealing with these lists of priorities at times in life where they're forced to deal with them rather than at times where they should have dealt with them. And so financial planning and planning for your family in the event of your death are matters that really should be given priority, but that daily life probably prevents us from thinking about a lot. I know for me in my own journey, while I'm busy running a business, I'm not thinking about my pension or my financials. I'm busy kind of worried about the files on my desk from day to day. And meeting Nick has certainly changed my thought process. And it has allowed me to sort of feel almost good and not panicked about the future. I think it's easy to feel panicked about the future, particularly when we talk about wills and death. And run away. That panic makes us run away from doing anything about it rather than looking in the eye and saying, okay, I need to deal with this. There's some stats here that only 20% or 27% of people in Ireland have a will, which is really interesting when you think of the fact that 100% of us will die at some point. There are 2 things that are certain, as they would say. The first is death and the second is taxes. And we're all going to, face that demise at some stage. I suppose youth and being young makes us forget about these things. But the minute we own a property of any nature, the requirement to have a will is something that should be forefront in our mind. In our practice, we have offices in Cork and Dublin. We see a lot of first-time buyers, and we always offer a service of doing a will on the purchase of a property, because effectively the purchase of a property means that you have an asset to dispose of in the event of death. We'll move later to talk about the different types of ownerships that apply to properties. But effectively, that is really when somebody should think about doing a will.
And Carrie, how straightforward or easy is a will to make? And can you give an approximate cost if somebody was to come in and make a will at those early stages with you?
Sure. I mean, if we're acting for a purchaser in a conveyance as a complementary service, we will always offer to do the will at the end of that transaction for them. So we would offer that to all our first-time buyers. A will doesn't take long really to draft. We would take the person's instructions. They would go away. We would draft the will. They would look at the will, and then they would come in to execute it. The execution is really important. It has to be witnessed, and that must be done in person. So sometimes we get inquiries as to whether this can be done digitally. It cannot be done digitally. It can be sent out to the person for them to execute in the presence of a witness and returned, but ideally we prefer people to come in and do it in office with us.
And Carrie, sorry, if somebody has made a will, okay, and we have a question in already just to say, can we refer to unmarried and cohabiting couples as we go through the talk? And if somebody has made a will and let's say they get married, does that affect the will that they made initially? So let's say they bought the house before they were married, they get married, or they're cohabiting. Can you maybe talk us through the process of how that would affect somebody's will?
Marriage invalidates the will. So if you get married, the will you've made before your marriage is invalid. That's as a result of the constitutional protection in Ireland around marriage. So you must make a new will when you get married. The second question about cohabiting couples is they should make a will, particularly where they own their property as tenants in common. So there are two ways of owning property. Most married couples own property as joint tenants. That means that the ownership of the property falls outside a will. If one spouse dies, the other automatically inherits that spouse's share in the property. Where properties are owned by cohabiting couples are friends, it's often the case that they own distinct shares, which is called they are tenants in common. And that means that they will have the right to leave their share by way of will to a third party beneficiary if they choose.
Carrie, somebody said that they made a will during COVID and this was made online. Is this still effective?
I don't know. I'd have to look at the document. Chances are it may well be, but you'd have to review the document in itself. If the will is a valid will made properly, one would assume it remains valid unless the person has revoked it or got married.
And I suppose there was an article in the Irish Times during the week, and they were talking about listing all of your assets. Is this something that you would do with somebody when they come in to write their will, where everything is really essentially held in a document together? Because somebody has actually just said, do I need to state each asset and where it is in terms of investment accounts? Or can I just say in general, all of my assets to whoever?
It depends on the way that the bequest is being made. So the more specific, the better. That's to avoid any sense of confusion or lack of clarity when the assets are being distributed. In the event that it is one beneficiary is being left everything in the estate, and that beneficiary would be aware of what the estate contains, it may not be so important, but we would always advise as much clarity and specific bequests as possible, certainly in terms of property assets. We always have a residue clause in a will, which will capture anything that the person doesn't list or anything that comes afterwards. So say if you make your will on the 1st of June 2024 and on the 1st of June 2025 you buy 3 apartments and they are not specifically listed, they will fall within the residue clause, provided it's not a joint tenancy and they're not passing to a survivor.
We've said
What's person as well.
sorry,
Cliona. I should have mentioned that we put up a poll there, and thank you for everyone who's responded to that. We've had over 90 people to respond, and just under half of the people have said that they have a will made. So it's about 45 out of the 91.
Good statistics.
Only, yeah. So it's slightly better than the average, but still it's quite a significant amount of people on the call that haven't actually done that. I suppose moving on to maybe enduring power of attorneys, Carrie, and sometimes I find when I'm speaking to clients that they don't really differentiate between a will and an enduring power of attorney. And perhaps you could maybe just explain what that
Yeah,
is and why that might be important.
sure. So there are two different types of attorney. One is a power of attorney, where you appoint somebody to assist you with your decisions. With a straightforward attorney, there is no requirement for you to lack mental capacity. So, giving an example, if somebody has an elderly parent who's perfectly mentally capable but just doesn't want to manage their own affairs, they can appoint somebody else as an attorney. If somebody lives abroad, they can appoint somebody else as an attorney to deal with their assets in this jurisdiction, and that works fine. Where it gets slightly complicated is enduring power of attorneys, because they're created really to support somebody if they lose mental capacity. They are created and they are now required to be registered with a government body for them to be valid. So it's a much more complicated process now. And as we have an aging population, and as particularly, say, our generation, you see your parents getting older, it's important to consider that their mental capacity may diminish. And in those circumstances, has the family considered provision to ensure that they are being provided for financially from their own financial pot sufficiently, and has that been considered? In many cases, it's not considered, and it's too late at the time of consideration. So an enduring power of attorney is best comprised and executed when the person has capacity to appoint an attorney to act on their behalf in the event of their demise, and that person then is a registered attorney on their behalf. So if they become unwell, or if they lack the capacity, people can make financial decisions in their best interests to provide their care in accordance with that power of attorney. Without it, it is complicated now with the assistant decision-making legislation in being, and it is much harder.
And Carrie, what's the difference then between a will and a trust, and which is better, or does it just depend on circumstances?
Again, every single case will be unique. So trusts are an instrument that allow interests in certain properties, assets, or businesses to pass. Whereas a will is a document that details on death what is to happen, the estate. It is possible to create trusts within a will to allow for example, a disabled child. Often a trust will be created in a will where a parent of a disabled child will have a concern that by leaving that child assets that they can't manage, that they will lose their very important entitlements within the state, such as disability allowance, the right to access medical care, etc., because they will then be means tested. So often in scenarios like that, trusts are created to allow for that dependent to be looked after without actually inheriting properties or assets that will affect their means. Other areas you see trusts commonly, and again, there are lots of types of trusts, and again, every circumstance will be different, but where say one child of a family is inheriting a family business, but their parent wants to carve out for the dependent spouse that is left remaining. You can often see businesses will pass by way of trust with a carve out for that dependent spouse to give them an income after the person's death. So you see lots of different varieties of trusts, discretionary and non-discretionary, contained in wills and actually entered into outside of wills for the purposes of generally passing businesses. Really important that clients know that these are very unique based on circumstances. They require careful consideration and generally very specific tax advice, which we would refer to their own accountants or taxation advisors or Alpha Wealth for. We would be very much driven by and assisted with financial advisors when creating those types of instruments.
Carrie, a question that's come in as well, and it's regarding, it says, can you speak about adult stepchildren as you go through wills and inheritance, please? Because obviously this is becoming much more common. Personally, I'm a blended family myself, so there are many, many different types of families, you know.
I might just step one step back because I think it's important for any blended family to understand that divorce, while marriage will invalidate your will, divorce doesn't, okay? So while in any real divorce proceedings, we will have provisions in the divorce agreement where one spouse will be stopped from looking to the other spouse's estate for what we call the legal right share, which is the right to have a share of the estate on death. The actual fact of a divorce does not invalidate a will. So if you have made a will prior to your divorce, leaving your wife X, Y, and Z, it needs to be reconsidered post-divorce. That's really important, particularly given that a lot of people think that obviously the divorce will deal with it. That's not necessarily the case if specific bequests are made in that will. The second thing is adult stepchildren are treated in law differently to children of a marriage. And the circumstances in terms of the bequest to an adult stepchild will be different in terms of the taxation thresholds that will apply. We are hoping to see that change in Ireland because certainly there is lobbying going on for it, but for now they remain in a category C, which is stranger.
Sorry, okay. I'm just reading. There are so many questions coming in, which is fantastic because it's obviously a very topical area. I don't think we'll get through every question.
I think just to touch on one point, and that is cohabitating couples need to ensure that when they're purchasing property that they understand the legal ownership that prevails in respect of the property. That's really important, that they understand at the time of purchase whether they have a distinct share as a tenant in common or a blended share as a joint tenant, because the ownership structure takes that property side of a will. In the case of a joint tenancy, the share passes to the survivor.
A question here, and this is kind of on what we're speaking about. So is there a way that I can protect the inheritance to my only child daughter? So in the event of divorce, that the property, or if the property is sold, the money from the sale of that property is protected from divorce. Objective of asset is for only child, and in the event of her passing, 3 grandchildren.
I'm struggling to understand.
So is there a way that I can protect the inheritance to my only child or daughter in the event of divorce?
Her divorce, the daughter's divorce.
That the property, or if
no, I
the
think
property...
it's the parents that divorce. It's the person who has the house. I think the question is, if I'm picking up correctly, they're looking to pass that particular asset to their daughter, but they're worried in the event of a divorce.
If it's a marital asset and an only child of the couple, then the divorce will deal with the asset.
Or it's the daughter's divorce. They've just clarified.
The daughter's divorce. I expect it's the daughter's divorce, and the 3 grandchildren are the daughter's 3 children. Good question, and comes up a lot. Not really, because if you provide by way of will for your daughter to inherit an asset, that becomes hers. And ultimately, if there is a marital separation/divorce, that asset is disclosed in what we call an affidavit of means in the context of those proceedings. The courts in Ireland to date do look at inherited assets slightly differently to acquired assets during the marriage. but certainly there isn't really a way of taking it um, out of the pot in a marital divorce. Even if it's left by way of trust, it's disclosable.
Some other very good
Just
questions, Carrie.
moving
Let's say
on.
somebody, can I just ask this question? Because I think it's really, if somebody has
Yeah, go ahead.
assets in different countries, do they need a will in each country
Yes.
or in each country?
Yes, categorically. And we get this a lot where people have a property here, an apartment in Spain. A Spanish will is required to deal with that Spanish asset.
Perfect. I can come back to
Just
some
to
of them.
move on, and yeah, interestingly, and again, this is something that we as advisors are often dealing with, and you've touched on it earlier, Carrie, that in relation to gift and inheritance tax, and you touched on thresholds. Interestingly, and even obviously when organising my own will for me kindly, I think it's really important for people to recognise that there is a little bit of planning that goes in, and having a very simple will of, just everything I have goes to my spouse.
Mm.
I am not convinced of, particularly given the way that I suppose we currently live our lives and scenarios that we face. So importantly, I think there is a little bit of tax planning that needs to be interjected. Kerry's touched on how you can kind of pass assets more effectively. We talk to our clients around the small gift exemption, which allows any individual to pass 3,000 euros to another individual. In the case of a parent to a child, obviously that's money that can be transferred very effectively without incurring any gift or inheritance tax. And then there's a little bit more of a creative, I suppose, approach in terms of, like, we talk about property assets, and obviously, unfortunately, because of the very strict thresholds, even for category A, which is a parent to a child of 400,000, given the value of properties at the moment, that can be exceeded. I definitely think that there needs to be some advice given. So I'd be very conscious, and I suppose, Kerry, from listening to you here, it seems to me that I think everyone really needs to have a will made if they're buying a property, if they're in a coupled scenario with potential assets, if they're getting married or if they're getting divorced. Would that be a reasonable kind of summary of who should be looking at wills?
I think the reality is if you die without a will, then it's much harder for your estate to be distributed. It's much harder for the real beneficiaries to obtain the benefit. And of course, it's much easier for there to be a dispute in the event that you have a separated couple where one dies without a will and the children are being deprived in circumstances where that wouldn't necessarily have been the intention. Perhaps there's a new partner. So a will is a document that allows a person's estate to pass as they intend it to pass. And again, it's a document that I say to my clients at various stages of life, this is not forever. You can renew and revoke this will and do a new will in due course if you wish. And a bit like financial planning in your 20s is different to your 30s, is different in your 40s. God forbid we'll have to think about our 50s soon. It's the same principle with a will. And I suppose.
And if you don't have children, Carrie, because that question came in, for somebody that has bought their first property, they don't have any children, do they need to make a will?
Yes, because again, the asset has to pass in the event of their death. So a will is advisable. And again, tax planning in a situation like that is also advisable because depending on what they're going to do with that property, they need to be aware of the taxation implications for any proposed beneficiaries. So again, having a consultation with Nick and the guys at Alpha would be really important in that scenario.
And this is probably a question for you, Nick, because it's come through as well. How much can you leave to brothers, sisters, nephews, nieces before tax?
So for category B, which is kind of blood relatives, so that typically tends to be obviously siblings and nieces and nephews, those as their natural blood nieces and nephews. The threshold was increased in last year's budget, not the one last week, earlier this week, which is 4,000 per person. But again, through proper tax planning, as Kerry has alluded to, I think it's important to understand about how we can pass assets more effectively. Gift and inheritance tax is a really cruel tax. It's like a double tax on monies that you've typically already paid tax on. And it's one thing that I would suggest, particularly using tools that Carrie's mentioned, to make sure that your intentions are being expressed. Just before we move on to the Q&A side of things, guys, Carrie, I know we spoke earlier in the week about changes in the budget, and one of them relates to business owners. Obviously, I'm a business owner myself, but the increase entrepreneurial limit from $1 million to 1.5 million, we had said potentially was going to benefit business owners to the tune of up to 115,000 euros. I suppose, is there advice that you give to business owners specifically around, I suppose, how they structure their business in relation to selling their business or in relation to buying a property or another business, for example? I'm just interested to know a little bit more about your services in terms of specifically
From our
business owners.
perspective, when we advise business owners in terms of transferring business assets, where we see this arise mostly, unless it's a sale of a business to a third party, is where the business is a family business and it's being passed to a family member. So there's lots of considerations within that. I would always do that in conjunction with financial advisors and tax advisors like yourself, Nick, because really I would take my lead from the structure that you guys put in place rather than me dictating the structure. Every business, it's like a family, it's different. And the requirements of the person disposing of the business and what they want will be different. So I'm normally not leading those discussions. You guys are much more in control. In terms of leaving a business by will or by way of trust, it very much depends on what the intention of the person passing that business is. We did one a few weeks ago where a particular business owner was leaving a bed and breakfast to a child, and we created a trust that allowed a carve out for income for the remaining spouse. So that is probably a classic sort of example to give, but it really does depend where somebody is scaling their business to sell their business to a third party. Then you're into obviously the sale of that business and looking at the reliefs that will apply by way of entrepreneurial relief, etc. Again, led by the financial advisory piece.
Very good.
So Nick, I think people, sorry, you glitched when you said about the category B, how much can siblings receive? People are asking, was it 4,000? But I think it was 40,000 you said, right?
That's correct, yeah, 40,000.
40,000.
That's the lifetime limit that one sibling calls to another or to a blood relative that's not a parent. But there is also the 3,000 a year small gift exemption, which is often forgotten, can be quite powerful over a long period of time. So as a planner, I'd be saying that if your intention is to pass an asset or indeed any monetary holdings you have, to think about whether that asset could be sold and passed on to time rather than physically just passing an asset, particularly when it comes to helping your children buy a property. I say to parents often, well, as much as I admire and I respect why parents have to help their children out, let's say give 50,000 to a deposit to buy their first home. Unfortunately, due to the restrictive limits we have in England, if it's two parents given to one child, that's 6,000 they're allowed to give them. 40,000 of the 50,000 then comes off that lifetime of 400,000. The ideal scenario in that case would have been potentially that if they could put some money into an account and build it up over time, not just the contribution, but also the growth of that money is not in any way treated as part of that 400,000 lifetime limit. And this is why planning is really important.
And Nick, for somebody that's getting an inheritance, that's getting an inheritance from their aunt had no husband, no children, can that person claim tax relief for themselves, their wife, and their children for inheritance tax purposes?
So again, in this instance, if the asset is being passed to the nephew in this case, then the limit is 40,000, again, with the exception of the 3,000 in that given year. However, if the asset can be passed to the nephew and their partner, then obviously that increases. Now, as Carrie said, the non-blood relative has the 20,000 limit. So now that goes from 40 to 60. if you
Sorry,
can include children.
I
Go
actually,
ahead,
sorry,
sorry.
I said earlier that stepchildren were category C. Sorry, I probably meant that in terms of cohabiting couples where the parties have married in advance, a second marriage, in other words, in advance of the step parent's death. The stepchild can be treated as a category A threshold. In
Okay,
cases
that's it.
where it's a second relationship and the parties are unmarried in advance of the death, the adult stepchild is treated as category C. Just to
Okay.
be clear, sorry.
Thanks for clarifying, Carrie.
Sorry.
So
Carrie,
really
oh,
what we're
sorry.
saying, yeah, so just to finish that question, and it's really important to understand that if there's an asset being passed and if it is going to exceed the threshold, or if there are other assets in the future that could do that, I think it's important to recognize and understand how these could be passed perhaps more effectively. But again, we need to obviously reach out to us. But you can go on to a few more questions. Just to mention as well, in relation to financial advice and obviously legal advice, the best suggestion we can make is that email Carrie. Carrie is an absolute, of oracle of knowledge and information, and she has a fantastic team working with her. Her email address is on the slide there. It's carrie@mdmlaw.ie, and obviously you can get into specific nuances, but we'll spend the next minutes trying to cover off maybe some further questions, perhaps, if that's okay.
And just to say, I suppose, Cliona, sorry, just to tie in with that, everything we say here is really general because I have never met two families who come in for a consultation and want the same thing, or where you would advise them to have the same thing. So everything in this area where people are planning for the future, they have considerations that they want included, will be very bespoke. So it's always a good idea to set up a consultation and not rely on general information on a webinar that you think might apply to you, but because we don't necessarily go into all of the exceptions to A, B, and C, may not apply to you. So a bespoke consultation is always recommended, both financial planning wise and legally, because otherwise you may not have the correct answer.
Thanks, Carrie. There's a few questions in just around kind of the cost of a will, and another one is how often should somebody review their will?
I would say the cost of a will is €100 plus VAT probably. If you are a first-time buyer and you're purchasing using our services, it's free. In terms of reviewing your will, I would say when life events occur or if your financial circumstances change drastically, we would always advise review after divorce, for example, because that is particularly important, or separation. Nick would probably advise, I suspect, Nick, I'm answering the question for you, any major financial life events would require you to consider your future disposal of assets.
Absolutely, that's exactly, and we suggest annual reviews with audience, but also, as you said, when there are life events or drastic changes in their situations.
Harry, you touched on it earlier, but I'm just going to, a question has come in. Please say something about wills, trust, and a young adult with Down syndrome, only child inheritance and subsequent bequest after they then pass. Please advise.
Okay, so I think the first part of that is that it's probably advisable that a trust is set up with trustees who manage the bequests or the estate in favor of that trustee and make sure that the provisions are made for that trustee's life that will allow them to have access to disability allowances and not affect their requirements to access medical care, etc. in Ireland. In terms of the estate passing after that beneficiary's death, that very much depends on what the trustees deem appropriate and what's left, I suspect, at that stage. Very difficult to sort of see around corners. If that beneficiary has no dependents, then you're looking at the taxation position carefully in terms of leaving to, say, cousins or aunts or uncles, etc. Because, of course, they're in the category B, category C, and therefore the taxation thresholds are much lower.
In terms of an enduring power of attorney and setting that up, Carrie, is it a different cost to
Yes.
a will?
Yes, it depends on what's involved.
Okay.
Again, you have to have a certificate obtained from the medical advisor confirming that the person is capable of creating an enduring power of attorney to show capacity. So it's a little bit more complicated. Again, it very much depends on each case, and we assess it in a bespoke way. But if somebody has become mentally incapacitated, it's probably too late.
And if somebody is naming executors on a will, what should they consider in advance?
The executor's duty is to simply distribute the estate in accordance with the will. It's not really to have an opinion or a view. So it's important that whoever you pick, you trust that they will execute and do as they are asked to do. It really is probably those you trust. For example, in a normal scenario, husband, wife, two children, generally each spouse will appoint each other and then one other. Often in that scenario, the one other may renounce because the spouse will ultimately distribute the estate for the other spouse who has passed. But very much depends on the circumstances. Again, when we would meet clients, we would say, who do you feel you would like to have? And we would have a general discussion, ensuring that they're happy with who they choose.
Just then, in terms of, sorry, I'm just looking through this. There's so many different questions. One has just said, we have not mentioned family partnerships for passing on assets.
Yes, I think that's probably more.
Have you frozen?
Nick's sort of area in terms of the angle.
Sorry, that's no problem. I think you could just kind of stalled there, Carrie, but you were saying that that's Nick's area, yeah. And
yeah.
It's an area, again, we go through, and as Carrie mentioned earlier, I think it's important for people to recognize that some of these areas are detailed, guys, and I do worry that, we look for these very simple solutions. We try and do a will online and do it as cheap as possible and forget about it. Just to mention as well, from a financial point of view, we offer consultations. For anyone that's interested, please look up our website for Wealth. And we are offering, in conjunction with solicitors, a reduced cost review. Basically, it's a one-off fee. It's reduced down by 50% for the month of October. Anyone who listens to this call in the month of October is listening live, and you can book using that code LAW50. And it's really from a point of view of financial planning. But I would suggest that people should get proper advice, with financially or legally. And as obviously Carrie has all the expertise and her team on the legal side. I'm not sure if any further questions in conscious of time. Perhaps I hope we've covered off most salient points of today. Thank you so much again, Carrie, for providing your absolute wealth of knowledge.
If there are specific queries, absolutely send me an email and I'll do my best to give as general and with a specific slant answer I can. It's difficult for me to answer emails on specifics without having a full consultation, but I'll certainly do my best to give any guidance that I can give from a general perspective and assist with any queries that we didn't get to today. Thank you to Nick and his team for the time. You guys are just so expert in what you do, and certainly you've helped me enormously in the things that I run away from in terms of financial planning into the future. I do feel better about my old age from a financial perspective, but not anything else, unfortunately. But thank you to Clean and Nick for having me. I appreciate it hugely. Thank you.
We'll finish up there. There has been tons and tons of questions, some of them that we have been unable to get to. I have provided Carrie's email address, and Nick's email address obviously is on the screen, and please do reach out for a consultation if required. So thank you so much to everybody for joining. We really appreciate you taking the time, and have a lovely afternoon. Thank you.
Thank you.
Thank you, everyone. Thanks. Take care.